Good evening. I'd like to call the September 17th meeting of the Titusville Planning and Zoning Commission to order. Stand for the pledge, please.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call, please.
Chairman Aton,
Here.
Vice Chairman Childs.
Here.
Secretary Grant. Member Faison.
Here.
Member Garrard. Member Scully.
Here.
Member Gellin.
Here.
Alternate Member Seidler.
Here.
Alternate Member Troutman.
Here.
All right, we have a quorum. Next order of business is approval of the minutes of September 3rd, 2025. Does anybody have any comments, additions, changes?
I'd like
Go ahead.
to approve the minutes as written.
I'll second.
Okay, we have a motion and a second. All in favor?
Aye.
Aye. Any opposed? All right, minutes are approved. City Attorney, would you read the quasi-judicial?
Absolutely. During the public hearing portion of the meeting, anyone wishing to speak on a quasi-judicial item must first sign a public hearing agenda card and sign the oath contained thereon, swearing to tell the truth, the full truth, and nothing but the truth. These cards are located on the table at the entrance to the chambers and should be provided to the clerk. Those speaking in favor of requests will be heard first. If you have photographs, sketches, or documents that you desire the commission to consider, they must be submitted into evidence and will be retained by the city. Please submit such exhibits to the city clerk. City clerk, have you received signed oath cards from persons wishing to speak before the commission, swearing to tell the truth, the full truth, and nothing but the truth?
No cards yet.
Okay. Staff and applicant, please ensure that all witnesses that intend to speak have signed an oath card and presented it to the clerk. If there is anyone present who has not signed an oath card that wishes to speak on a quasi-judicial item, please submit the card to the clerk at this time. City clerk, have all agenda items been properly advertised?
Yes.
Okay. Regarding ex parte communications, in the event that a commission member has received an ex parte communication, verbal or written, outside of the hearing, the commission member shall disclose the identity of the person, group, or entity with whom the communication took place and the subject of the communication, including all opinions or facts discussed. Any written communication must be disclosed and made part of the record. Also, in the event that a member has conducted an investigation or site visit or received any expert opinions regarding the quasi-judicial item, said visit or opinion shall be disclosed. If written ex parte communications exist, verify the applicant has received them and has had the opportunity to review it and is ready to proceed. Regarding the order of the presentations, first, a commission will receive staff's presentation, followed by the presentation of the applicant. Following the applicant's presentation, the floor will be open to public comment. The applicant may make a rebuttal. Witnesses may be cross-examined by the applicant, a party, the commission, or a staff representative as authorized by the commission. The commission's decision must be based upon competent substantial evidence and pursuant to Florida statute. If the commission denies an application for a development permit, the commission shall cite the applicable portion of the ordinance, rule, statute, or other legal authority for the denial. Sir.
Thank you. Next item on the agenda is our first petitions and requests from the public present. If anyone cares to speak on any item not on the agenda, you can have up to 3 minutes to do so. Anyone care to speak? Seeing none, we have no old business and a new business, number 9A.
Good evening, Christy Anderson, Senior Planner. So this is item 9A. It's a right-of-way vacation number 2-2025 regarding Orange Street. The applicant, Mr. Bruce Moya, professional engineer of MBV Engineering Incorporated, is requesting to vacate a portion of the right-of-way located on Orange Street, described in Exhibit A on page 31 of your packets. The public right-of-way is located between South Brown Street and South DeLeon Avenue and is east of the Florida Coast to Coast Trail. An aerial image has been provided on page 24 of your packets indicating the area. The proposed right-of-way vacation contains approximately 12,610 square feet, measuring approximately 50 feet wide and 252 feet in length. The portion of the Orange Street right-of-way, which is included in the a portion of the Orange Street right-of-way, which was included in the area associated with this request, was previously vacated in 1974. So there is some history on this street. That was done by Resolution 56-1974, with the condition that if either side of the vacated Orange Street were to be sold, the right-of-way would revert back to the city. The resolution also required utility and drainage easement be in place over the vacated area. Records indicate that the previously vacated right-of-way was reverted back to the city. Subsequently, the Orange Street right-of-way fronting lots 1 and 2, approximately 100 feet in length, was re-vacated in 1988 under Resolution 53-1988 with the provision that a drainage and utility easement be reserved over the entirety of the vacated public right-of-way. Several attempts were made in the early 1990s to reopen the right-of-way to the public, but however, the attempts remained unsuccessful. Staff has found that the proposed vacation is inconsistent with the comprehensive plan, specifically Transportation Element Policy 1.6.2, which states that the city may vacate street right-of-ways only if it does not prevent reasonable connection for existing and future publics. The existing right-of-way currently provides a means for pedestrian and vehicle transportation. There's an existing sidewalk network which provides direct access to the Florida Coast to Coast Trail ramp. And the property to the south of the right-of-way also has driveways accessing onto the public roadway, which must be maintained. In 2014, the city adopted Ordinance 49-2014 to include review criteria with every vacate request. The ordinance was adopted in response to concerns about the long-term ramifications of losing pedestrian and vehicle connections between streets. Vacating rights-of-way should be carefully evaluated. A vacated right-of-way cannot be reversed, and its loss is immediate and forever. The city should only approve vacations if they do not result in negative impacts on the current or future needs of the city vehicle, bicycle, or pedestrian circulation systems or access to private property. Based on these findings, staff has provided a recommendation of denial of the request, and if you have any questions from staff at this time, I'd be happy to answer them.
Vice Chairman Childs.
We, this didn't come before us recently, or like in the last year or so. We didn't have this come before us, did we? Because we had another vacation that sounded very familiar, and I was trying to remember what it was. But
So I believe that vacation was to the west of the trail.
okay.
And that wasn't probably the extension of the Orange Street because it looks like it had originally gone through. And it was a unimproved grassy area
That's what I
with
thought, okay.
utilities. So it was a
didn't
little bit
include this
different.
kind of, it wasn't including the street, right? It was including.
Correct. It was
like
kind of
sidewalk or-
a street that was never developed,
Right,
basically.
okay. Thank you.
Member Grodd.
Thank you, Mr. Chairman. For staff, I have a couple of questions. It intrigued me, the history that you just read on the record regarding a vacation that reconstituted itself back to the city and a second attempt that was approved but also reconstituted itself. I'm kind of familiar with that from riding my own bicycle around the area, both growing up and now older, that road network in that part of Titusville has existed and probably, from what I can gather, existed before the buildings were built that are served by the streets. It seemed odd that you would vacate a paved street that connects out to Garden Street and also connects to DeLeon, which is a collector road. And when I looked at the information that you provided, I just was really inquisitive as to if all those conditions were the same in I think you said 74, the original vacation, and then again in 88. That's just kind of very odd to me that it would have passed muster in 2 attempts that vacate a public paved street with a sidewalk on it that connects from an arterial road, Garden Street, to a collector road, DeLeon. Is there any more history that explains that?
Not necessarily, aside from, I guess, the reverter clause that was in place had possibly made them feel more comfortable to grant that to where it wouldn't be permanent. I don't think that that's something that's normally practiced within right-of-way vacations. I know that there were issues regarding a fence that was constructed that blocked access. And that was resolved, but the existing 100-foot right-of-way that is vacated currently, if you look on the property appraiser's website, it's still showing as private property. And the city, I guess, realized that in the early 90s, that the access needs to be maintained, and with the issues with the fence going up, they were trying to get that property owner to provide the property back to the city. And I think that they were throwing some numbers out there that the city wasn't interested in purchasing the property. So there was an extensive back and forth of trying to reacquire that property, but it remained unsuccessful.
So at this time, it's a public dedicated right-of-way that's dedicated, in this case, the public, the city of Titusville. And this is a request to vacate that same section,
No.
same dimension?
No. So if you look at the property, let's see a good photo. I believe probably the zoning map on, let's see. The zoning map on page 29 shows the subject property in question, the current right-of-way, and you can kind of see how that ends. And there's no right-of-way extension to the west because it is private property.
So the paved road that appears on Google Maps on a street view that curves and goes to the north
Correct.
is private property.
Correct.
And this is an entrance into the private property or a terminus the other direction from the private property. And as the road exists, there's no impedance. You can ride it, walk it,
Correct.
drive it. Nobody's blocking it, but that's just by the nature. They don't want to block it. Does that sound right?
That's correct.
And the last question I have is, in the vacation of the right-of-way that was done in 74 and in 88 and now in 2025, a little familiar, and it may also ask the attorney to chime in if you can help me. Platted rights-of-way from a subdivisions aspect can oftentimes be abutting other properties, wherein subdivisions of the land originally dedicated a right-of-way entirely from the original description that became subsequently subdivided and subsequently dedicated a right-of-way. In that context, property abuts a road, but the road came from the other property. Otherwise, you can have a grid type of design in which the properties become platted, dedication of right-of-way occurs, and it comes from that property, so the road is internal to the subdivision. In the case of the former, my experience is if you request a vacation, you can't assume it becomes your property because you may never have been the property that provided the dedication. In the latter example, where the right-of-way came from the parent parcel and property abutting the right-of-way became platted, a partial vacation, half a road, or entire vacation, opposing people, the rights-of-way dedication goes to the property owners whose property originally dedicated and still currently abuts it. So when I looked at this grid of property, my question is this right-of-way from the property who's requesting its plat, or is it just an opportunity in which someone abuts a right-of-way and they, abutting it, want to vacate it, or did so in 74 and in 88? That may be a big question that doesn't have an exploration answer right now, but it is one I would have that, if my experience is helpful, who gets the right-of-way when it's dedicated is a question that may have to be answered later, or at least answered at some point.
I don't think I have a good answer for that, but I know typically if the right-of-way is vacated, it's typically split down the center line and offered to the adjacent property owners to either side.
I could probably use a good example of a situation that might look like that. Hopkins Avenue goes along the railroad track. I'll just jump into an opinion. Some of it abuts Hopkins Avenue abuts the right-of-way of the railroad. In other areas, abuts residential platted subdivisions. Somewhere that right-of-way existed and became dedicated and used by the public. If you vacate east of the right-of-way of Hopkins, it may never have come from the property that became subdivided. They abutted a right-of-way and they subdivided from it. In the case of the Florida East Coast Railroad, they abut the right-of-way and the railroad came before the road. So in some cases, that dedication would go one direction towards the railroad if a vacation scenario worked. The other one would not necessarily mean these property owners have a right to the property just because they vacated it. So I would simply ask that that question be explored before City Council gets this to make sure that the vacations that occurred in the right channel, that the vacation goes to the property owner that's making the request, as opposed to vacating it, and it may need to go to somebody else. I know it's a difficult question, but that's what we get here to ask.
Okay.
Thank you.
Yep.
Any other questions from the members before we open the public hearing? All right, I'll open the public hearing. Do we have any cards, Lori?
Bruce Moya.
Good evening.
Yeah, good evening. Bruce Moy with MBV Engineering, representing the property owner for this vacate request. This is a pretty unique situation. I don't recall seeing too many like this, where you have a road that is public, then private, and then public again. Very interesting. It does, in fact, connect to De Leon, so you have that connection. But De Leon also directly connects to I forget the name of the road that runs east-west, but it's a direct connection. This Orange Street is kind of more like a driveway if you've been out there and looked at it. There's parking that backs up directly into the street. There's the owner on the south is the same person that owns the corner piece, so he owns the portion of that right-of-way that was vacated. So you have parking on the street, which is really undesirable to the city to have parking backing onto a public street. The sidewalk on the north side stops about 100 feet west of De Leon, but the sidewalk on the south side goes all the way through to the trail. And that's not even in the right-of-way. That's on private property. So whether the city has an easement or it's just prescriptive, whatever. So the vacating the right-of-way has no effect on that sidewalk that connects to the trail. The proposal is to do pretty much what is out there now, is to grant the city an easement and the utilities so that they have access. Our plan is not to block any access of this roadway. And we would grant an easement with the conditions that we would continue to allow access as they do, so people can still go through and get to their properties. So, really nothing would change physically out there. It would just not be the responsibility of the city of Titusville to maintain it or even have the condition that it's in, which probably needs a little bit of work right now, if the condition that it's in. So that would relieve the city of the obligation to maintain this, and it will allow the property owner to be able to do something with his property, because right now he really can't. I don't know if you've seen it. There's an existing building there. There's a portion of what, I don't know if that used to be a part of a building, but there's no roof on it to the west. He can't do anything with that unless he has some additional property. So the plan is to fix up the property, do an addition, make it look nice, and he can't really do that unless he has the property. So that's why we're asking for the vacate, because that allows us to actually do something with the property. And it doesn't change the fact that utilities and access will be maintained as it is today. And it just relieves the city of any obligation. So now you would have, you won't have that situation where you have the private, public, private. You'd have just that little piece that runs north-south that would still be the city. And who knows, maybe someday they'll vacate that and then you won't have to worry about any of it. But the situation that's out there, I would think if I was a city, I wouldn't want the responsibility for it. So that's really why we're doing the request. I think that I know what the staff said about complying with the ordinance, but I think we do because we are, maintaining access and maintaining exactly what's out there. So I don't think that we're in violation of what the requirements are. But I can, clear that up if there's any questions about that. So that's really all I have to say. If I have any questions, I'm happy to answer those for you.
Member Faison.
So I see what you guys are requesting, and it doesn't make sense in some way how the owner on the parcel to the left, or excuse me, to the south, also owns the parcel to the west of what you're asking. It doesn't make sense. But likewise, the parcel to the west, what they had done was they restricted their boundaries of what they requested to be vacated to the boundary of the property and not include the road. And that's something different than what you're asking. So as I look at this here closely, right, and then somebody else actually owns that piece of parcel too, which makes no sense. But the road is owned by somebody else. So I'm asking, why are you asking to include the roadway, right? Mm-hmm. Which also limits or now has the parcel to your south using private property to gain entry to their own property.
Yes. So however they access their property now, they'd maintain that access. And you're right, it would go through what would be private property should the vacate be granted. Just like anybody using that road that goes all the way through is going on private property to get to where they're going. And that would be then it would be the responsibility of the property owner.
So my question to you is, right, why do we not put the request to the edge of your property and leave the roadway on the city side?
I don't know. For one reason, I think that I don't think the city, maybe they would, maybe they won't. That would make it a substandard right of way per your code if we reduced it. And then two, really, we really would like the extra property so that we can actually improve the property to the north that the applicant owns. So they can do something there. So the more property he gains, the more improvements he can make, if that makes any sense to you, because there's a limit to how much you can do. There's what they call a maximum building coverage requirement in the city of Titusville. So depending on how much property you have, that's how much building you can have.
Correct.
So in order to really use this building, to have as much property as possible.
To extend the building?
Pardon me?
To expand the building?
And to expand it, yes.
Okay. All right, so we're looking at expanding the building, so you need to expand your footprint so that you can expand more.
Well, yeah, possibly.
Okay.
I mean, it would be nice if we could at least use the part that's already walled in.
See, because my overall concern, right, is that if the vacate was granted, that would be private property, and then the parcel to the south could essentially no longer have access to their property.
Well, no,
True?
we would record a document that says that they would have access. Everybody, the public would have access. The public would have total access, unblocked access, as it exists today.
Okay.
And I believe that's pretty much the same as what you see to the west of us, is they have an easement that grants.
So the parcel to the west of you does not own the roadway. So the parcel to the west of you.
The roadway itself, right?
Correct.
They own what used to be right of way. The roadway is owned by some other entity.
Correct. So the parcel to the south of you and to the west of you do not own the roadway. And so my question to you is, why was your request along the lines of the parcel to the west?
Well, that whole right-of-way was vacated. I don't know how the property was divided up. I mean, I believe, I haven't seen the file on how the property was divided up. So I'm assuming that the corner piece got half the right-of-way. And maybe this other third party, maybe they owned the south piece at one time and they got part of that and never sold that part of it. I don't know the history of the ownership part of it.
Right.
But technically, that right-of-way was the same width as the right-of-way that we have in front of our property.
Correct.
So it was split in half.
Correct.
Half to the north, half to the south. and then somehow somebody sold something and maintained something.
Yep.
But that was way after the fact. The plan on this one would be, we have a verbal confirmation from the owner to the south that he's in favor of this request. And he's actually to the point where he wants the applicant to have the entire right-of-way. He doesn't want his half. He wants to give us the whole right-of-way. So all that property would go to the applicant and not be split in half.
Okay. Thank you.
Member Grodd.
Thank you, Mr. Chairman. A question for the attorney, if I may, and I don't want to put you on the spot. So I'm looking at the survey that's on page 30 of 62. I'm sorry, I can't turn it so it's visible. I have to pay a 7-day fee for something. Anyway, that survey illustrates 25.6 feet in a shaded area to the property to your west, and it identifies it with the verbiage, vacated portion of north half of right-of-way, Orange Street. So in right-of-way vacations, it's quite possible that you could vacate half a right-of-way because, as you just mentioned, that the representative, mentioned that the owner to the south might be in agreement with me. The owner would give it all to me. That's all good, but that's not factual. It's just a matter of what you said happened. He isn't here to speak for himself.
Correct.
So the point is, it looks from this survey that the north half of the right-of-way of Orange Street was vacated at some point. What's the question's answer for the south half? Is it vacated or is it remain?
No, I mean, it is possible to vacate less than an entire right-of-way. In fact, it happens,
And that was-
or at least it's requested frequently. In fact, the last one I handled in another city, I think it was like a 26-foot right-of-way, and they only wanted to vacate 8 feet because they had, a building issue and they needed more space. So that does happen.
It's typically like this. You're dealing with quote-unquote paper streets. I'm sure you're familiar with the term, wherein there's no improvement, but the plat dedicated a right-of-way, and somebody found their sheds in the right-of-way and nobody wants it, so you go through a process of vacating it. What happens to the division, as I was trying to allude to, is when does the division of a vacated right-of-way fall away from the center line? Call it right and left, call it up and down, doesn't matter. It goes to the south, it goes to the north. You mentioned that the owner to the south is in favor of it. You're vacating the entire right-of-way. There's no guarantee that the applicant's going to obtain ownership by the vacation. He's only going to be able to obtain half of it. The other half goes south, so as to speak.
Right, and before this meeting, I'm not, what you're saying is correct, and I don't know if, and maybe the attorney can make a position about it, but I did speak to an attorney that does a lot of work in the county, and I said, have you done vacates? Is there something when you get that vacate, if the owner of that property to the south provided a letter to the city council that they do not want that property, would they grant all the property to that person to the north? And she said, absolutely. So just by them agreeing to that, whether it's a notarized letter or whatever, when the city puts it in the books, they can grant it to the one property owner. And the reason we're vacating the entire right-of-way, where when you look at the survey, it looks like we already own half of that right-of-way. I think that's the survey you were pointing out.
I'm looking at page 30 of 62. It's a survey.
Okay, well, it's on my page 30 of 62.
Yeah.
I don't know if that's the same thing. But when we made application, we thought we owned that, and the city had no record of that ever being vacated. And the way everything reads, especially in the property pages, that is not our property. So to clean everything up, we're asking to vacate the entire right-of-way, just to make it clean, because we don't have paperwork that shows whether we own that property or not, for sure.
Well, I'm not sure tonight's action is going to clean anything up. It sounds like it's a morass of confusion based on a history of some perhaps questionable vacation procedures. My question begs a simple answer. Do you have the authority to vacate the entire right-of-way? And when the right-of-way's vacation goes to property owners adjacent to the right-of-way, will it in fact go to you, as you assume? Will it go to the property to the south, which I could presume it could, depending on how the plat recordation dedicated the right-of-way. And right now, I don't believe you can tell me, and no one else can tell me, how the vacation affects the property by the plat that the vacated right-of-way comes from. That's why I spoke earlier on about this. The other question I think is fair and reasonable is if you wanted to vacate the whole right-of-way, and if the property owner to the south was a part of the same plat, so therefore the two property owners north and south of the requested vacated 50 feet of right-of-way will effectively become the owner of the vacated right-of-way. Once that application's provided for by both applicants in joint, when the division of the property occurs after vacation, I'm sure you all can work out the ownership, because then it's a simple matter of saying it was vacated and title opinion says this one goes this way and this one goes this way. I've had some experience with vacating right-of-ways that went south, and this kind of reads from the history as if it already started that direction. I don't want to contribute to it, and I think at least fairly enough for me, there's enough questions about the effect of vacating it, the effect of the history of vacations in the past. The property owner to the south, and they want to join you, I'd welcome them to do that. It may make the deliberation a little easier.
Yeah, and it's my understanding that that we can make this clean. That's my understanding, and that would be something we will provide, obviously, to City Council as the final paperwork, is that they can say, they can grant that property to the applicant. And if that,
We're hopefully
whether-
going to give them a recommendation, and it might be kind of important that the
Yeah.
P&Z gets to look at that same kind of
that,
agreement.
that's.
And I
fine.
don't know if everything I've said is making sense, but I'm concerned about the right-of-ways vacation result.
Yeah, and I think based on the history, the way it's laid out, because you do have half and half to the west, that's what would happen. So without a statement saying otherwise,
Not necessarily.
I'm just going by what has already happened. So the fact that that is to the west, the way it was divided in half, and the way that we had maybe potentially per the survey, that was what we had before, that maybe it was vacated, maybe it wasn't vacated, that it would be a half and half deal based on the plat. So regardless, we'll make sure that we research that and have that ready for the city council so that it will go to one owner.
So what you're stating is the boundary survey you provided that's on page 30 of 62 shows the boundary inclusive of this 50, this north
Right,
half
and
of
that
the
was in
right.
question because city doesn't have records of that. So that's why we are making the request.
Doesn't have the record of the vacation?
No, right,
Okay.
yeah. So, yeah.
Yeah, and if I may, I do tend to agree with you, and I would disagree that just a letter would transfer ownership. You bring up a very legitimate question as to if that right-of-way goes away, does it go to the adjoining properties or not? And assuming for sake of argument that it does, it would go half to the north, half to the south. The city, unlike I think what I just heard, the city cannot just grant it to the party on the north. That would have to be a land transaction of their own, where there would have to be a transferring of partial deed transfer to transfer that property to them. Property appraiser would have to get involved. Tax collector would have to get involved to know who to tax next year and so on
It
and so
sounds like the
forth.
experience I
So
mentioned.
it's not just as easy as just a letter. But to the point that everyone says, get it cleaned up, yeah, that might be necessary, but that's gonna take multiple steps.
And whether it's a quick claim deed already to go, gets recorded with the vacate, I mean, I know that we can do that.
Yeah, we're mixing metaphors here. It's not a quick claim deed.
Well,
What we've got is a vacation right-of-way,
I
public
understand,
lands,
but it can
so-
be part of that action. I mean, we can make it, I think we can make it happen to where when it all gets recorded, that the end result is that it will all be one piece of property.
Well, if I may, Mr. Chairman, my concern is really based on the applicant makes a request for vacation of an entire right-of-way that affects a southern boundary property, who abuts a right-of-way, who, from the photograph I see, takes access from the property, or may take access. The conversation you're having is appreciated, but there's no factual confirmation that the property owner to the south is supporting you. And we had a letter that was forwarded today from staff that there was an opposition to the right-of-way vacation because it was going to impede turning movements for an adjacent property owner. I had a little hard time trying to put that letter to the property when I started looking at the aerial maps. Is why I mentioned that I was having to rely on looking at this from a Google Earth to see what was going on. However, if the application for this came from the two property owners abutting a right-of-way that they are both party to the subdivision that created it and dedicated it to the public, and if the two property owners enclosing the right-of-way are simply extending the vacated right-of-way that was done before, so there's really no public street, even though I could ride a bicycle down it or walk down it, if somebody, as Christy mentioned, put a fence up and said no go, private property is private property. So having this section of right-of-way may not serve really good public purpose any longer, and a request combined in applications clearly illustrating who gets what from the vacation would make it a cleaner, more objective point to look at than tonight's request is somewhat mired in some confusion, historically speaking, and then the questions I've posed that there isn't an answer for, but we really should explore that answer.
I understand what you're saying.
Good.
I don't necessarily agree with what you're saying, but I do understand what you're saying. I've done a lot of right-of-way vacates as well. Regardless, I mean, one person makes application to vacate a right-of-way 100% of the time. I don't think I've ever seen a dual application right-of-way vacate. Somebody either objects or they don't. Whether we get the property or not is really irrelevant to our request. Because if we get it, that's great. It gives us a little more flexibility. If we don't, we don't. And I understand how it would work. Now, if we provide the information so that we do get it, that's great. I don't know if that's all that relevant, for what we're requesting. I'm just kind of in full disclosure telling you exactly why we're doing it and what we're doing and what we hope happens. And I think we can provide information because, if I vacate a right-of-way and that owner gets the property that he doesn't even know he's getting, he might not want it, but he gets it, doesn't he? Well, unless he objects to it. People get property all the time and that doesn't benefit them at all. They just pay more taxes. So unless they come here and object to it. So I haven't seen any objection letters from any property owners on this road.
There were two.
The only one that I saw was the one from Public Works. I didn't see any from, if there are, I didn't see them.
Do you have the letters that we were forwarded?
I do. I don't have them printed out. They were to the property owner to the west, 11 and 12 South Brown. And then to the west of South Brown Avenue, there's a letter that came in. Both of these came in late yesterday.
Yeah, that's probably why.
I looked at them on my phone. They both used the words road closure versus opposition to the right-of-way, or vacation of the right-of-way. They object to closing the road. So potentially the access easement would relieve that, but
I'll forward both of them to your email so you have them. Yes.
I don't see how that would affect them since it's already vacated south of them, but.
The point I was trying to make, and I'll continue making that point, the history that's been provided to us to deliberate your request is riddled with questions. How did it happen? Why did it happen? What happened when it reverted? Partial vacation, full vacation. Those questions aren't answered. They're just historical perspective. Your request is to request a vacation of right-of-way that affects other properties. Right now, anybody coming to the end of that right-of-way has a right to be within the right-of-way, behind your business with the cars parked in the street blocking the access. But you have a right to do that because it's a public road. Mm-hmm. Even if the extent of that is to travel on, I have no way to know if the people west of you just inherently use that old city street, which is what it sounds like it represents, and the old city sidewalks that were vacated from authority, ownership, and maintenance, as you mentioned. But somebody drives down the road and goes to their property. Nobody impedes them or nobody stops them. We don't know if there's an easement allowing for that. So with yours being terminated, it may aggravate their accessibility. Maybe they got an easement back in 74 from the vacated right-of-way, and that's how they travel. We don't know anything.
But didn't you say they do have an easement? I thought I heard in your comment that there is an easement on the existing vacated
Yes, that was
right-of-way.
part of the condition of the 1988 vacation.
Okay. So there is an easement to allow access on the vacated right-of-way that's in the middle of the road now.
But is the 88 vacation and the condition for an easement, the recordation of the easement, is it the same right-of-way that was vacated in 74? Or is it an additional piece of right-of-way, two different
So
events?
74, everything was reverted back to the city, and then in 88, that portion that is vacated now was vacated in 88. And then it states that the provision that a drainage and utility easement be reserved over the entirety of the vacated right-of-way.
Was it?
I'd have to confirm that includes access as well.
But again, I stress the
So,
point
so
is,
you have maybe it's a serious problem here, if there's no access there now.
somebody has a serious problem. I
So-
don't have a serious problem.
Well, yeah, so I think what we're doing won't change that, and it definitely won't make it worse, because we will give you recorded access and an agreement that says that the public has access on this roadway and the sidewalk, and utilities have a right to maintain and enter the property so they'll have more than what you have now. And it sounds like to me, I'd want to get out from under it as a responsibility, but I'm not the city.
Vice Chairman Childs.
So, I kind of get some of his points. Sometimes he uses a lot of words, sometimes I have to break it down, but I think part of what he's saying too, that maybe I don't know if he said this or not, but if you vacate the whole thing, the south side, they're gonna get property, just like I said, they're gonna get property now almost automatically based on maybe history of how these things go. And now they're responsible for it. And they were like, I don't want to take care of the road. Mm-hmm. But so I guess what he's saying too, I guess, is we don't have that information that they, we don't have the letter from them. We have your word, which I'm fine taking. But maybe I guess that's part of what he's saying. But also, I kind of want to clear up this. So you're saying you'd give, or the applicant would give an easement. Now, that brings up a good point too, is like, how do you give an easement for property that might not be yours already either? But, because, I mean.
Yeah, it's simultaneous recording.
Yeah, all right. So let's assume that is the case, that you get the easement, or you're giving the easement, Christie, for it being inconsistent with the comp plan. Doesn't them giving the easement of the right or an easement to travel through, doesn't that kind of negate the whole, it just says does not prevent reasonable connection for existing and future public transit, pedestrian and non-motorized and motorized vehicle trips. If there is an easement, you're not stopping that, right? Or am I wrong?
I suppose that could be a subjective determination. Staff doesn't see it that way. Staff feels that there is an improved right-of-way with sidewalks and streets, and provides access between the two roadways currently. So the city is in support that is in conflict with the comprehensive plan. But like you said, it is referencing prevent reasonable connection or access. So I suppose somebody could interpret that access being provided through an access easement still is providing that.
I mean, that's kind of how I see it, is like, if you're just reading it, it seems like I think maybe the intent behind it was, we don't want to lose, the ability for people to travel through. And I think if you're not losing that ability for people to travel through, then what would be the harm? I would think that this specific policy would be to say, we don't want to lose that access for the public. And if they're guaranteeing a public access through on the road, and they're going to take care of it. So is it partially that maybe the road won't be taken care of because, but yeah, well, yeah, you can travel through, but you're going to be traveling through mud and stuff. I mean,
If
I
I,
don't
if
know.
I may, that is one of the very real concerns. First of all, it would have to be an irrevocable easement, because you give an easement today and then you would draw it and there's nothing that can be done. So, but even assuming it would be an irrevocable easement, there's still a matter of upkeep, and how they're going to maintain the road, how they're going to maintain the area to make it travel. You know, streets right now are the responsibility of the city. You know, you have something that becomes a private area, and it's out of the city's control at that point, so.
And there's no, like, part of the easement that says that they would have to take care of it either? Is that part of it? Like, you couldn't?
I mean, you could have language in there, like
Yeah.
anything, it's a matter of enforceability. I mean, we're gonna be having to run to circuit court to try and enforce an easement? You really
Right.
can't. I mean, that's, you
Yeah.
know, we'd have to probably have some sort of maintenance contract that goes with it, but it would have to run in perpetuity, run with the land, so that some landowner that buys this building, you know, 50 years from now understands that they have to maintain that road because of a public easement. It just creates layers of issues. Nothing that can't be gotten through, but there's a lot to unpackage here.
Okay. Yeah, this is a difficult one. All right, thank you.
Member Faison.
So members, I want to bring to your attention that black line, if you will look on page 24 of 62. So that black line is what's called the center line. And that's what separates the north from the south parcels. And if I were to assume that that black line that goes to the property to the west, when they were mentioning the easement, that would be, the easement would be that area between that gray line and that center line. So if I look at that center line, right, his property is to the north. His complete side of his property is to the north of that center line. And so my question to him earlier was, why was he not requesting from the center line on his property? And then that would negate having to worry about the property to the south, because the person to the south will still own, or that city-owned property, which is really quote unquote the roadway, will still belong to the city. So I mean, I understand the goal is to get as much property as he can, from what he said, to extend his building as far as he can, because he needs that extra distance. But that would include, as we've been talking about, him then taking over, or his client taking over the roadway. And I think that, again, let's just look at that center line, that center line of the roadway of that parcel, the parcel. He's to the north of it. His property is completely to the north of it, and the roadway is completely to the south of it. I just want to bring that to your attentions.
Just one other, you know, to throw something else into the mix, and I know you have 100 different issues here, but the setbacks that our land development code have exist for a reason, and most cases it's a matter of safety. Having buildings too close to the roadway is more of a hazard. So the fact that the stated objective here is in order to, you know, grow the building out to the edge, even if there's a easement left there so that vehicles can get through, they're going to be getting through there right adjacent to a building without the benefit of a setback that would normally be in place. So just another issue that may be part of this.
Alternate member Singh. Go ahead.
Thank
Yeah,
you. On the same.
you don't show up well on my little thing here,
Oh,
so
thank
I'm
you.
sorry.
Oh, I just stick it up. On the same page 2462, as I'm looking at the property. And can you tell me where the addition and how far it's going to come when I'm looking at these buildings here? How far into this vacated property? And then a second question is, once a vacation is granted and you've built upon, what is stopping? Can you block the road? Can you prevent by putting up a fence? What happens there?
Yeah, so we would propose in the language of the easement agreement that we would not block the road. So that would be clear that we cannot do that. We would have to maintain perpetual access, not uninhibited access as it is now. And then if we grant the easement over where the right-of-way is, we can't build in the easement. So that would prevent any building south of where that line is, because you can't put a building in an easement, in a public easement.
Are you talking in the center line?
No, the entire, where you have this right-of-way, instead of having right-of-way, you would have easement. And it would be a public easement, and we can't build a building in a public easement. So we could not come any further south than that building already is now.
Okay, and you had mentioned that you were looking to vacate this property so you could build an addition. If this property is not vacated to you, are you still able to build and improve upon this property?
No.
How long has they owned the property?
2 years, yeah. Yeah.
Thank you.
Member Garad?
Thank you, Mr. Chairman. So that dialogue was very helpful, your question very helpful, because it focuses on what I'm kind of deriving from this conversation. If you were conforming to the zoning district regulations in effect, where setbacks measured from boundaries are measured, requirements standardized so many feet from the property line, by acquiring right-of-way, you move your property boundary, opens your property for development. Right now, you're constrained, and if the illustration on page 24 is somewhat close to correct, you have all but no setback from the property boundary on the south to the building. You have an ingression in the right-of-way of the parking spaces. So I would kind of guess at best you're a non-conforming existing development. And if I was correct, the nonconformity is an issue to itself that impedes further development of the property unless you can bring it into conformity. If something tragically happened, conformity can be achieved by some tragic event, acts of God, weather, elements, something raises the property, now it's vacant, you meet the code. If you're going to grant an easement, as you just stated, that's going to impede development within the public easement, because you can't develop in the public easement was your statement, I don't really see the net difference between leaving the right-of-way as it exists and providing an easement that you're still zero setback from. You won't ingress, you won't build in, and the road's still the road and the sidewalk's still the sidewalk, and the city maintains it. That's not necessarily good, but that is a fact. If you grant the easement, you're still restricting the development in the same manner that the right-of-way restricts it. I don't see the net gain.
Yeah, no, that wouldn't be the case, because then the setback would be from the south, the new south property boundary. But the
Wouldn't be able to build in
structures,
the public easement.
not structures, no.
Well, you said you would not build in the public easement. Grass is not
But we can
buildable.
still go east-west.
I'm looking at a line that sure wonders if the setback's in conformity with the existing building to the west boundary. It looks like it's also all but a zero setback. If there is an ownership boundary between the corner property on Orange Avenue or whatever that street is, Brown, and, or Garden Street,
think
that's not your property, right?
I think it's a zero setback to the west, I believe. I don't think we have an issue to the west.
Well, so there's the wall that encloses the parking area.
Yeah.
So I think that the building setback probably meets the 10-foot.
Yeah, and even if we don't build the building all the way
This
to
one
the
too?
wall, we would be fine. If there's a setback from the west property boundary, it just means we can't build the building any further west than the setback line.
Right, I'm having to guess at this because the information, I just don't have all that right now. My guess was based on page 2462, which is an aerial photograph rendering what I'm seeing.
So from what I understand, we are conforming now.
And if you're not going to build in the vacated right-of-way, which is your statement, what's the difference in leaving the right-of-way opened as it is and vacating the right-of-way?
Because there's a maximum building coverage requirement.
He needs it for the square
So
footage
say you have the 10,000 square foot property, and your building
I'm
limitation is
familiar with it.
20%, you can have a 2,000 square foot building, and that's it.
I'm
That's where
familiar.
we are here.
Right.
So
That part I
we're-
easily
yeah,
understand.
That's where we are. So we can't do anything with this property because of that building coverage requirement.
So the
But the
acquisition
setbacks
is,
are not the issue. Setbacks are fine.
okay, the acquisition is merely to make your composition ratio allowable for further development.
You got it.
And is the intent to put a roof back on the section to the west of the part
Partially,
that
but
sticks out?
maybe, yeah, I mean, we haven't even got to that point yet. Because we can go nowhere unless this gets
Okay.
approved, we can go nowhere, so.
So you can't
this is
really
our-
tell
this
us
is
what the
step
plans
one
are
of-
other
of-
than to
of-
expand it.
Of a potentially long process to get through site plan approval.
Member Drop.
Yeah, so that brings up a question too. I mean, if the long road down is to possibly put a roof up on this, then at that point, then now you're looking at boundary issues and setbacks of a building, because now you've enclosed it with a roof later on down the road. But, so by getting this square footage that you're trying to get, you're hoping to build out east, I assume, in that vacant lot that's to the east?
Possibly, you could go both ways, we don't know. I mean, I'm pretty sure we can go pretty far west. We might have to knock that west wall down and bring it in some to build to the west, but that would be possible. I think it's only, because this is what, industrial or heavy commercial?
M1.
M1
Yeah,
industrial.
So the setback is maybe 5 feet, maybe 0, I'm not even sure. So we
yeah.
could, I mean, we could easily take that wall down and build within 5 feet of the property boundary to the west. I mean, we would have to meet the set, whatever that setback is, we'd have to meet it. And then we would have to, obviously we'd have to add some parking and, all the other improvements, retention, and, the site gets used up pretty quick when you start adding all the requirements. You can't just put a building on it and do nothing else. You got to have, parking, retention, landscaping. There's a laundry list of things that we have to do.
Member Garad.
A follow-up question, so that I understand the applicant, you mentioned you owned adjacent property representing the owner. I'm looking at this tax roll map or aerial map, and it's illustrating parcels, I believe, in shaded gray. And Christy, maybe you can help, because I don't think you can see what I'm looking at. Maybe you can on page 2462.
I don't know if my pages are numbered like yours. What'd you say, 20 of 62?
24 of 62. So it shows a T-shaped building fronting Garden Street, and the bottom of the T abuts Orange Street and the part of the right-of-way you want to vacate. There's a vacant parcel of land along Orange Avenue adjacent to the T-shaped building. There appears to be other buildings west of the parcel that contains a building. It's like ownership lines on this are different than your boundary survey. The ownership of property is based on the plat, so these lots don't really exist because they're under the blanket of the boundary. So you own vacant land on the corner, not you yourself. The applicant's property ownership includes the corner of Orange and DeLeon,
Yes.
all the way to Garden Street.
No.
So the white building that's on this map is not a T-shaped ownership. It's just a square?
It was at one point. This was all one ownership at one point, but no, that is, so the rear line of that building that fronts Garden Street is our north property boundary. But I understand, I don't know the history, goes way beyond my time, and.
So somewhere in time,
But this was
somebody,
under one ownership at one time. I understood that, and it got separated out at some point in time.
so that I have to continue I apologize. I'm just really concerned with your statement that you can't expand the building because there's a ratio governing the maximum development potential based on open space building footprint. Did you make that statement recognizing you also own vacant property at the corner of Orange and DeLeon?
Yes.
So the ratio would still remain non-conforming and only become conforming if you vacate this right-of-way, or only become able to conform to the ratio standard when you
No.
expand the building.
To expand it. But right now, we are basically right at the maximum.
Right. Inclusive of the vacant property.
Correct.
And last question, and you said that originally, at some point, this was all comprehensively owned.
It's
Under
what
what
I
ownership?
understand. I don't have any proof of that, but that's the story I was told.
So,
I mean, we were talking back in the 60s, you know, so
so if zoning laws and comprehensive plan rules were in
didn't
effect,
exist back then, yeah.
you don't know
Maybe
that they
some
didn't
zoning
exist.
laws, but no comp plan. Comp plan was like the late 80s, so.
Okay, but the sale away from the property would have created this difficult situation.
That was one of the reasons we got the one variance that we did get.
Okay. Thank you.
Yeah, so that T-shape, the building behind that was all one property at one point.
Do
I
do
don't
you have
remember-
a,
Tell them who you are.
Yeah, hi, I'm Michael Grosso. I'm the owner of 1018, all these lots that we're talking about. And that was one property at one point. I don't remember how we confirmed that, but it was all originally one property. And since we've purchased the building, we've just renovated. They were in very poor condition, and we've renovated 1018 and 1020, completely renovated. New roof, new stucco, new painting, lighting, and we have good tenants in there now. And we're just trying to improve and see what we can do with the other two lots there. So that's real. I don't know what the legality is or anything like that, but the buildings were in terrible shape. They're in great shape now. We have good tenants there, and we're just trying to do the same thing and just improve the property. So that's it. Thank you.
Mr. Chair, if I may.
yes, sir.
I'd like to bring something else to the board's attention, and if you go look at that map, and I know a lot of you have been on that page 24 of 62, that aerial map. I'd like to bring your attention to something that I've been looking at just while we're sitting here is, we heard some information about the west end of this area that's under consideration having already been vacated previously. And we heard that the property to the south connects to the property to the west and that they own all of that. Actually, there's a little, if you look at the map right now, and we have the red box, which is the area that's under your consideration now, and then just to the west of it, you can see the one parcel up top that goes down to like midpoint of the right of way. And then there's a very long strip to the south of that. That's an interesting parcel because I've been on the property appraiser's website, and that property does not belong, at least it's not deeded to the same property owner that's to the south or to the north of it. It's actually deeded to a Beeson's Electric, which, according to the Secretary of State, Department of Corporations, has been defunct since 2002. But their trim notice has been going to the applicant. So it appears anyway, and not making accusations here or anything, and it's not an accusation anyway, but it seems like they may have an interest in that other half. And it might be worthy of hearing from the applicant if they have any property interest, or if they've at least been paying the taxes on that vacated right-of-way that sits to the west of this, because that might be a piece of the puzzle that you haven't been told yet. You've been led to believe that this is a completely different property owner that owns that and did that prior vacation, and it seems like they may be involved in it, because Beeson's hasn't been in business for a while, but somebody's still paying their taxes every year, so.
I just asked him, he says he has no idea, he has no involvement in that property whatsoever.
Okay. So that, I mean, and again, and we can do it after this meeting, you make whatever recommendation you're gonna make to council, but that gives me some homework to do between now and council meeting to find out, who is paying the tax on that, because it's still deeded to Beeson's Electric. So.
Member Gallen.
I'm just curious, what is the property being used for currently?
The two buildings are being rented out to Florida Gaming Control Commission. They're renting it for storage. So they use it for air-conditioned storage space.
So storage for the Florida Game Commission.
All right. Anyone else have any other questions for the applicant? Do we have any more cards on this, Lori?
No, sir.
All right.
Thank you.
Thank you. Oh, Emma
I was going to ask the applicant's representative one question.
Yes, sir.
With some of the information that I've asked questions regarding, based on my experience, that makes me ponder is this vacation as well presented in information to the P&Z Commission to consider recommendation and subsequently the City Council. Would you consider, in lieu of going forward, postpone this, get confirmation or joint application for vacation from the southern boundary owner, have staff figure out the answer to my question, where did the plat dedication come from, which properties assumed would obtain ownership by vacation? I don't believe the assumption is necessarily inaccurate or accurate, but it's a question. And allow those questions to be answered together with finding what the vacated right-of-way affecting the property owner that you're speaking of, allow council to research that so that when this comes back at whatever time's convenient, we can explore new information, additional information, and with that, at least myself, I would feel more comfortable knowing the answers to my questions regarding ownership representation, authority to vacate, where does the right-of-way go upon vacation? Assumptions can't be gathered. I think you have to know, is the owner to the south going to receive some of it? Then he can work the, quote, deal out with you, end quote. And certainly, it would make me more comfortable to make a determination pending staff's review of that as well, because they may have a different recommendation once they establish a little bit more information.
Put me on the spot. So
Is time
we
of
made
the
this
essence?
application a very long time ago, and we finally got here. Sometimes I tend to give a lot of information that I don't really feel is relevant to the request. I mean, I am a planning and zoning member, or was for the county for 11 years, and the chairman of Indian Harbor Beach currently. And so I look at the relevant facts to the application. The application was made to vacate the right-of-way. Who gets the property, to me, is irrelevant to the application.
What if,
Right-of-ways are vacated all the time. Nobody really
that's,
has ever spoken about who gets what. That's what happens after it gets approved. So I don't know if that's a reason to delay this longer than it's already been delayed, because we have been, I don't remember the date we made the first application, but it was a long time ago.
just
And we
keep in
finally
mind what
got
I've
here,
said.
so, yeah.
You're assuming you're going to obtain right-of-way because you made the request for vacation. If the right-of-way did not come from your property's plat, the right-of-way vacation will revert to the owner that the platted right-of-way came from. And no one has tonight told me, where is the plat's ownership? Is this right-of-way vacation a party to your ownership by plat? Or is it conversely only the ownership of the plat that would represent property to your south? So in other words, you end up with a request you paid good money for, you get down the road and some legal counsel says, you don't own it, Joe owns it, because the right-of-way came from his property in the plat. You weren't a party to
But
that.
the plat dedicated the roadway to the city.
A plat dedicated the
A
roadway
plat.
to the city.
So-
Your property is part of a plat.
Yes.
The property to the south, is it the same plat? Was the right-of-way from that plat or your plat, or your two properties from the same plat?
Yeah.
We don't know.
I believe the property to the south is also on the same plat.
That's a simple answer to the first question.
Yeah, and I know that there's been a lot of discussion about different details, but I just wanted to remind the commission that section 17-33B, the Code of Ordinance, provides the criteria that needs to be reviewed for a right-of-way vacation. And that's provided at the end of page 9 and 10. And that is the standard criteria that needs to be reviewed in order to grant a right-of-way vacate.
City Attorney?
Yes.
Oh, you were lit up there, so I didn't know you had anything.
Yeah, so we feel we meet all the criteria.
Yeah,
We've got
I
approval
think
from all the utilities, we've got, you know, we feel we've met that, and we would appreciate a vote.
Yeah, my other concern, I haven't spoken on it, is you say it doesn't matter who owns the property, that's settled afterwards, but as the city attorney said, we're talking about an irrevocable easement, potentially with the perpetual maintenance of the road as part of that. And so somebody's got to sign up for that. And if we don't know who owns the property, who's signing up for the perpetual maintenance of the road?
Understand. And we'll obviously, we'll clarify that before, we've actually submitted a draft document for you to look at. We'll do that research now that we know that that's a potential issue, so make sure that that gets recorded properly. I mean, those are details that we can work out with staff, you know, after all that happens, kind of like what we do with binding development plans and a lot of things like that. If we need to verify ownership, verify who gets what, provide the paperwork from that owner that says, hey, I'm giving it to you, and record all that at the same time. And as long as staff knows that it meets your desires, you can condition it on that, so that all that stuff's taken care of before it ever gets recorded. We'll be happy to do that, and that's kind of what we do all the time.
All right, thank you. I'll close the public hearing and bring it back to the commission. Member Charles, Vice Chairman Charles.
There's a lot of issues. I mean, I want to say that with the comp plan 1.6.2, that if there is a perpetual easement granted, that solves that issue. But like you just said, like who takes care of that? Who's signing up? We don't have those people who've come before us and say, oh yeah, we don't even have that. Just someone saying, you know, not even in writing, just someone saying, yes, I would take that on and upkeep that road, because the neighbors that are around there, you know, maybe 20 years goes by and the guy who really takes care of the property right now, and we trust probably would, is not the owner anymore. And now you have, you know, people to the south trying to get their trucks out, and they're trying to get through the sand or something because there's no road there anymore. So I don't know. It's really, I'd like to say like approve it with like a lot of conditions, but I think the conditions would be a lot, and I'm not even sure what legally, you know, as far as the details that, I don't know if that we have all the details that we would need to list it all out of what we would need to condition that approval on. So that's my thoughts right now.
Member Faison.
As council has pointed out, that one slither of property that we haven't spoken on, it's in question. Because if somebody buys that other piece of property, which is that small piece of property south of the property to the west, which is, if that piece is purchased and blocked off, right? Because it's not a part of this conversation. If that piece is purchased and blocked off, then it doesn't matter what happens with that other piece of property. And so, this is definitely a quagmire. This is definitely a problem. And there needs to be a solution for it. But I don't know if this is the right answer for that situation.
Member Garad.
My thoughts I've just mentioned is perhaps retreat and come back tomorrow with information that would assist us in making a determination. I don't think the continuance requires re-advertisement. I don't know that for sure, but maybe Chrissy can let us know. If the continuance was made for 2 weeks, it doesn't sound like the enormous thing that would allow the applicant to dig a little deeper into the answers.
Other than the applicants asked for a vote tonight, so.
And the votes that may come may not.
Yeah. Anyone else? Anyone have a motion? Member Garad.
I'm going to follow staff's recommendations, recommend denial of the request based on its inconsistency with the comprehensive plan's criteria that was spelled out, I think you said page 9 of your report. Is that right? 1.6.2?
That's correct.
I'll second that.
Member Faison seconds. Any discussion before we do a roll call vote? Seeing none. Lori?
Member Troutman?
Yes.
Member Faison?
Yes.
Vice Chairman Childs?
Yes.
Member Scully?
Yes.
Member Garad?
Yes?
Member Gellin?
Yes.
Chairman Aton?
Yes. All right, so the application is denied unanimously. When will this go before council?
It is scheduled for September 23rd for City Council.
Thank you. Item 9B.
This is a request for a conditional use permit number 8-2025. The applicant, Mr. Brian Winters, on behalf of Blue Origin LLC, is requesting a conditional use permit to operate a light manufacturing use on the property located at 7980 Grissom Parkway. The property is zoned light industrial services and warehousing M1 and has a future land use of commercial high intensity. The western portion of the property has a conservation future land use and is zoned open space recreation. The M1 zoning district permits light manufacturing uses, however, pursuant to Code Section 28-210C1A, a conditional use permit shall be required when the future land use designation is not industrial. Therefore, an approved CUP is required to operate the proposed light manufacturing use at this location. The property is approximately 67.33 acres in size. There's an existing 180,000 square foot office building on site, which was previously utilized by Eckler's as a warehouse, distribution, and trucking facility. The applicant intends to make interior renovations to the existing facility and has stated that there will be 100 employees working in 2 shifts from 6 a.m. to 11 p.m. The conceptual site plan shown on page 50 of your packets was submitted as part of the application and shows additional feature improvements, which include a 50,000 square foot 2-story building near the east side of the property adjacent to Grissom Parkway, and 142,000 square foot building shown on the south side of the existing building. The conceptual site plan does not propose any encroachments into the conservation future land use and open space and recreation zoned area. The property has direct access to Grissom Parkway to the east, and the surrounding properties to the north, south, and east are all vacant commercial property. The conservation area on site is approximately 650 feet in width and buffers of the existing and proposed buildings from the Verona single-family residential subdivision to the west. The nearest single-family residence is located approximately 1,350 feet from the existing structures on site. Staff is providing a recommendation of approval of CUP 8-2025 to permit a light manufacturing use at 7980 Grissom Parkway, consistent with the proposed concept plan. And I'd be happy to answer any questions you have from staff.
Anyone have any questions? Member Garad?
I was wondering if Mr. Bayos was going to come request this in person.
Okay. A couple questions. Does the applicant own the property, or is it under contract, or are they just going to be a tenant? Do we know? You should. I
The
guess I could.
application page should indicate ownership. Just provide me one moment. So it looks like Antonio Romano is the current owner, and I believe that that is the authorized agent for the Blue Origin. So I believe that they are the property owner, but the
We can ask
applicant
the
can
app- okay.
confirm that for you.
And then the second was is probably more for staff. Is there anything related to the proposed use and the parking that we should take into consideration as to, is there enough parking under when it was a warehouse versus a light industrial use?
I don't believe staff has analyzed that, but there's no external expansion to the building. So I don't assume that the parking would increase. However, with the proposed improvements to the site, the additional buildings, they would have to come into compliance with all of the parking for the site. So as they do improvements and move forward with site plans, they will have to meet all of the required parking minimums.
All right, thank you. Member Faison?
I'm glad that you asked about the use of this property because my concern or question would be about the noise and light that it may produce for the neighborhood just behind it. And so not knowing what light manufacturing is going to do, I don't know how noisy it's going to be or not be, or what kind of environmental pollution, if you will, that may aggravate the neighborhood just behind it.
I believe all operations are going to be within an enclosed building, so I believe staff had minimal concerns about the noise issue, in addition to the extensive buffer between the single family and the existing and proposed development.
And smells? Again, because it's manufacturing plant, and we don't know what they're making. And so that's kind of a, how can you, we don't know what they're making.
I believe the applicant can probably provide additional information on their
Are
intent.
they here? Oh. Oh, I'll wait for that then. I'm sorry. I didn't think they were here.
It's okay. I didn't open the public.
I know on page 51, they provided their narrative
Yes,
and their
please.
intent for the request.
Thank you.
You can fill it out after if you want, just so we keep things moving. Sorry. Oh, I'm sorry. Alternate member.
Thank you. On 38 and 39, I'm curious, how do we correct the boundary location and the corresponding future land use? There's an open space and recreation zoning, conservation future land use, and on those pages, it is asking or stating that we correct the boundary location. And also, what are we doing to protect or the conservation area? It's a 650-foot wide. It's by the single family. What sort of barriers as we're building and these buildings are going up? It's a wetland zone area, single family, so we have noise, we have buildings going up. We're not sure what's going on in them. Are they manufacturing things? Do we have hazardous materials? What is in these buildings?
So the use will be limited to light manufacturing. In 2013, the property was rezoned, and the wetlands and that conservation area were reassigned. So the applicant at the time of the rezoning provided a wetland delineation survey, so those lines were actually corrected to represent the actual wetlands on site. As to where a lot of our wetlands and our conservation land use were based on aerials and not necessarily survey data. So that property was currently rezoned in 2013 where the wetlands were right-sized to meet where they are on the site. They will be required if they are developing near the wetlands to provide a wetland buffer to protect from any secondary impacts from the development onto the wetland area, and that's required by St. John's and DEP. So whenever they go and pursue permits, they will be required to provide those buffers as well.
So just to clarify from staff, I'm sorry when you're ready to go, but we're really just focused on the CUP to utilize the existing building. Any additional construction or anything like that will all have to come back or either come back.
That's correct. Future improvements will need to be relatively consistent with the concept plan that's provided to you tonight. If not, they would have to, if it does deviate substantially, they would have to come back and revise the concept plan.
Good evening, Carol Hunter, Director of Construction for Blue Origin. So nice to meet you. Thank you for having us. So to answer your first question, what type of manufacturing? We're an aerospace company. This would be manufacturing metal small parts, so sub-assemblies that go into our rockets. So machine parts, so lathes, CNCs, things of that nature. And so it's basically taking raw stock metal components and then milling it to the precise measurements that we need. That's the manufacturing that's going to happen in the facility.
Thank you.
Any other questions?
I don't have a question, but I can relay some experience to this, that the majority of the work that Blue Origin or any of these industries do have to comply with noise ordinances, decibels for the workers. The majority of that stuff is restricted down to under 85 decibels. There are times where they exceed that, but it's only minimal times, so that noise, things of that. As far as construction goes, I can understand the noise and things like that, but as far as a completed structure, things that they do within, the noise is kept down to OSHA requirements and things of that nature.
And since this is an aerospace company, the machines that we have in there are very high-tech, and they're very insulated because of the precision that we need. So these aren't, what you'd see in a mechanic machine shop. These are very sophisticated, expensive. Also, this would be our center of excellence. We will be piloting some robotic equipment, robotic manufacturing. So very cool, sophisticated, sensitive equipment. So not what you would typically see in other heavy industrial manufacturing.
Is it robotics that Blue Origin manufactures, or another company that you're going to use the robotics
Another
from?
company for our manufacturing.
What company is that? I'm just curious. Do you know?
We're still testing out a couple different brands
Okay.
to see what gives us the best product.
Okay, thank you.
All right. Anyone have anything else before I close? Well, I guess have any questions for the applicant? Do you have a card?
I haven't made a card.
Okay.
It's my first, I'm a homeowner in Verona. And thank you.
Yeah. So, go ahead and tell us your name and address.
My name
but
is
then
Megan
please-
Englehart.
Please fill out a card.
Yes, I will fill out a card for sure. My name is Megan Englehart, Englehart. I am a homeowner in Verona. I live in one of the homes closest to the Grissom building we're talking about. My main concerns are about noise, light, and pollution in general coming from the building. I know sometimes manufacturing things might just be emitting a tiny bit of pollution at a time, but if I'm living behind that over time, I don't want that accumulating in anything near us. So I'm just kind of curious about who regulates and holds accountable these standards that we have for making sure that we're not polluting our beautiful Titusville environment. That's my question. Thank you.
Thank you. Member Gellin?
I had a question for the young lady right there. What was the hours again? The hours of operation?
Yes, 2 shifts, 6 to 11 p.m. When we are running full production, but that's not every day. We're not at full production yet. As I mentioned before, we're still kind of testing out some equipment.
Okay. And weekends or just Monday through Friday?
Monday through Friday.
Okay. Thank you.
Lori, we have any other cards?
No cards.
No cards? All right. With that, I'll close the public hearing and bring it back. Vice Mayor Child.
I was just going to say for the resident, I think code enforcement's the one who does the enforcement for that stuff. So if you have any issues, you just call code enforcement and then they would address it. But, yeah.
Is there a regular schedule that they would test or enforce? Because I wouldn't know if they're polluting or how to get a report
for the water
or
and
something like
environment
that.
stuff. No, they don't. No, they don't do anything like that. It's just if someone complains about.
If there's a complaint, they would, but there's no ongoing testing or regulation to hold anyone accountable for anything. So they can agree,
Not for
but
that.
not do.
It's just they would need evidence, otherwise they would be testing all over Titusville. I don't know, but I know.
Well, manufacturing area, you know.
Yeah, I don't think that there's any regulation. Do you know,
Yeah,
Chris?
it would be in Environmental Protection Agency, I'm assuming, as far as, their testing and regular, I don't know
Yeah.
how all that goes together, but it's apparently the applicant has some information.
So part of our process to move in is industrial wastewater pretreatment. So part of the application process that we go through with you, in addition to the CUP, is to submit information for the industrial pretreatment, and so we have to provide sample points for that. So your regulation, your utilities regulate what we do. So, and then St. John's regulates any stormwater pollution, and then DEP regulates air permits. So a lot of that is enforced that we have to maintain permit compliance for.
Cool, thank you.
Just a question for the applicant's representative along the same lines. Your contract work with Blue Origin's usually affiliated with, as you said, aerospace, but affiliated with the federal government to a large extent. And doesn't the
Sometimes.
federal government in your contracts with them require you to
No.
conform to all these standards that concern?
The standards are regulated by other chapters, by other agencies, regulatory agencies. Our NASA contract or Department of Defense contracts require other parameters for testing requirements, not necessarily for environmental regulations that's already enacted by either the federal or the state agencies.
So you don't report annually to your contract?
We have to submit that we do comply, yes. As part of winning contracts, we do have to show that we are compliant with all of the regulations, yes.
So to kind of help the concerned citizen, you're being watchdog through your contract with the federal government.
Correct.
The state government, as you mentioned, regulates stormwater through the St. John's Water Management District.
Yes.
Air pollution, FDEP, City of Titusville, and code enforcement on matters that are local. So,
Yep.
Thank you.
And part of my job is to make sure that we are compliant with all of our regulations.
See, you're much better representing the application than Mr. Bayos would have been.
All right, we've already closed the public hearing. Any other items? If not, does anyone have a motion?
I'll make a motion to recommend approval of 9B CUP 8-2025 conditional use permit for Blue Origin.
And I will second it.
Any other discussion prior to roll call vote? Seeing none, Lori?
Member Faison?
Yes.
Member Gillen?
Yes.
Member Garad?
Yes?
Member Troutman?
Yes.
Member Scully?
Yes.
Vice Chairman Childs?
Yes.
Chairman Aton?
Yes. Motion passes unanimously, and we appreciate your expansion. And on this side, is this your first facility outside the bounds of KSC?
No, we have a warehouse, but this is our first manufacturing facility outside. We are interested in doing more outside of the Cape. As you've probably seen in the press, our founder is very eager to expand our manufacturing and get to a higher rate of flight cadence.
Great.
So before you go, number one, I'm glad to see that we have something of this nature moving to this community. Working in aerospace for a long time in cybersecurity out at Lockheed and other agencies out there in Orlando, this is excellent. I hope that your program partners with some of our local schools here and let these young people see what robotics can do, what modeling and simulation, my background, can do as well. I would love to see your program, see your facility once it's complete, to let these young people see what this area has to offer.
Absolutely. We have a Club for the Future where we will have our engineers, our aerospace engineers, go out to the community, to the schools, different functions, different outreach to show and do show and tells, also support robotic competitions. And so, yes, we're very active in the community.
Perfect, thank you.
Thank you very much. I see item 9C has been pulled, so did we need to make any comment on that or not?
Just that it was previously advertised, but there was an issue with scheduling with the applicant, so the item will be fully re-advertised at a future meeting.
Okay, great. With that, this is time for the second petitions and requests from the public present. Does anyone have any comments or anything to say? If not, we'll move on to reports. City staff?
None.
City attorney?
I just want to clarify something I said earlier, just to make sure that it's said during this meeting. Talking about that little strip of land that I said that the trim notice had been going to the applicant's address, and that is the way it's addressed. However, digging further in the tax collector's website, taxes haven't been paid on that property since about 2015. And some tax deed certificates have been issued, but there's been no sale of the property. So I'll talk to city staff tomorrow about whether the city may want to acquire that piece back or let it go to whoever bought the tax deed. So,
Well,
but I
there's
just want to make sure the record was clear that, you know, it didn't have any involvement of the applicant.
Well, there was no consistent buyer of those tax deeds.
No,
they-
not
they
at
were
all. They're
just
all out of
investment-
state and they're from all over the place.
Investment yeah.
Yep, yep. And the tax deeds were going for like $9 or $10 because that little piece is only valued at $580 according to the property appraiser. Yeah.
I got 20 in my pocket. You guys are good. Yeah, I actually knew Gordon Beeson of Beeson Electric, and he passed away probably about that time, so that's probably has a lot to do with it. So.
What I kept thinking of, and my concern kind of came from when I first came to serve Titusville, there was the gentleman who appears in many public hearing dates that complains about the right-of-way vacation and the lines didn't match up and somebody doesn't own the street. And 2+ years of hearing that, I wouldn't want to have set up a example of that happening again.
That's our job, right? Do it right. I have no report. Any of the members have any reports? Seeing none, we will stand adjourned.